dictation at 120 per minute, 120 words per minute. There will be many proper nouns. Take care. Start. The challenge in the present appeals is to an order passed by the High Court of Madhya Pradesh, whereby the revision filed by the appellant or nominated officer of the Hindustan Unilever Limited was allowed. However, the matter was remitted back to the trial court to revisit the evidence adduced by both the parties. So far, it relates to the appellants Nirmal Sen and the company. Brief facts leading to the present appeals are that a complaint was filed by Inspector of Food and Health on the basis of a sample taken in respect of Dalda Vanaspati brand ghee manufactured by the company in terms of the provisions of the Prevention of Food Adulteration Act 1954. The sample of Vanaspati ghee was taken from the godown of Lipton India Limited, which was found to be adulterated as the melting point was found higher than the normal range. Initially, the complaint was filed against the directors of the company as well as that of Lipton India Limited. In terms of the directions of this court, it appears that the learned trial court passed an order absolving the directors of the company, and the prosecution was ordered to continue against the appellant. The said order is not on record, but it appears that no proceedings were continued against the company in as much as it has 4 accused. A complete reading of the order passed by the trial court does not lead to an inference that the company was represented at any stage during the course of trial. It is to be noted that in the aforesaid mentioned judgment, there was no order passed by the learned trial court to convict the appellant company of any offence. The appellant contested the proceedings and was convicted by the trial court. With the aforesaid discussion, the learned additional sessions judge affirmed the conviction of the nominated officer, but the conviction of the accused was set aside and they were acquitted. The High Court in its order noticed that if the company is acquitted of the charges, the said benefit will also directly go to the nominated officer. A glaring and patent defect in the judgment of the trial court as well as in the judgment of the appellate court was observed by the High Court. Thus, the conviction and sentence passed against the appellant, being a nominated person of the company, was set aside and the matter was remitted back to the trial court for passing fresh judgment. The learned senior counsel for the appellant company raised an argument that the company was not convicted by the trial court. Therefore, the High Court in revision could not have passed an order of retrial, more so when the company was not given any notice of being heard. In terms of Section 6 of the General Clauses Act 1897, unless different intentions appears, the repeal of a statute does not affect any investigation, legal proceeding or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture or punishment, and any such investigation, legal proceeding or remedy may be instituted, continued or enforced, and any such penalty, forfeiture or punishment may be imposed as if the repealing act or regulation had not been passed. The question as to whether penalty or prosecution can continue or be initiated under the repealed provisions has been examined. In another judgment, the assessments were completely under the Income Tax Act 1922 after the Income Tax Act 1961 came into force. There was a search on the premises of the SSE. The revision returns were filed after the Income Tax Act 1961 came into force. The victim in the present case was a girl of 2.5 years of age, and the first information report was lodged by her father. As stated in the FIR, the victim was taken to the doctor for medical attention, but she was already dead and there were marks of bites on her body. After registration of crime, the inquest was conducted, which recorded black and bluish colored marks are visible on both the cheeks and an injury is invisible on the left cheek. Similarly, both the lips are bitten. An injury is visible on the chin as well. It has recorded that there were bite marks on the chest and stomach of the victim apart from signs of forcible sexual assault. Soon after the registration of the crime, the police station in charge caused arrest of the appellant and conducted spot panchanama. At the spot, full pant of the victim, pieces of flesh of an adult male were found. The doctor stated that when the victim was brought before him, she was already dead and had found wounds and bites on her body. The other doctor deposed about medical examination of the appellant. A grocery shop owner was examined. He stated that on 11/2/2013, the accused had come to his shop and had purchased Parle biscuits, but he could not remember who was with the accused at that time. The witness was therefore declared hostile. In the examination of the appellant under section 313 of the code, when the evidence was put to him, the appellant stated that the evidence was false. Similar was his response when the evidence that the blood of the victim was found on his full pant was put to him. The trial court thus, by its order passed on the same day, awarded death sentence to the appellant on 2 counts. The death sentence was subject to confirmation by the High Court. The matter concerning confirmation of death sentence and the substantive appeal by the appellant against his conviction were dealt with together, and by its judgment and order presently under appeal, the conviction and sentence passed by the trial court were affirmed by the High Court. The Criminal Law Amendment Act 2013 received the assent of the President. In the instant case, the offence was committed when the provisions of the ordinance were in force. However, the Amendment Act having been given retrospective, the question arises whether imposition of life sentence for the offence under section 376 subsection 2 could mean imprisonment for the remainder of that person's natural life.